Hello, everyone, and welcome to Uncivil Law. And for today's case, we're dealing with a journalist's request to get access to certain government records dealing with electronic surveillance and whether or not those records can be disclosed. This is the case of In Re in the matter of application of Jason Leopard to unseal certain electronic surveillance applications and orders. In this case, Jason Leopold is trying to unseal evidence, and the court doesn't want to let him. So the question is, can he get access to this evidence? What is the evidence? And what are the standards for review by the court? Let's get started with this. This case involves three kinds of court orders authorizing electronic surveillance: judicial warrants issued pursuant to the Stored Communication Act, court's orders issued pursuant to Section 2703 of that act, and court orders issued pursuant to the Pen Register Act. The Secure Communication Act can be used to compel the disclosure by a provider of electronic communication services from wire or electronic communication that's in storage for 180 days or less. The Secure Communication Act orders can be used to access, with notice to subscriber, the contents of specified wire or electronic communications held by a remote computing service with or without notice, subscriber records held by electronic communication or remote computing service. And then finally, Pen Register authorizes law enforcement to register a pen register and a trap and trace device. Pen registers captures outgoing metadata. Trap and trace devices capture incoming metadata. Collectively, they tell the government such things as what number a person dialed, what address a person was emailed from, and when someone sends a text. They do not, however, capture the content of those messages. The Secure Communication Act warrants, the orders, and the Pen Register orders allow law enforcement to collect different kinds of electronic information, but the mechanisms of their authorization are similar. The government submits an application, and the court issues an order granting or denying the application. Thus, all three generate similar records that are then filed with the court. The application and the supporting documents are filed by the government, the order is issued by a court, and the court clerk's docket contains the entries. Heretofore, the United States District Court for the District of Columbia has routinely maintained all these materials under seal. In July 2013, Jason Leopold, an investigative reporter now with BuzzFeed News, applies for the District Court for an order to unseal some of the above materials. The applicants and the United States Attorney's Office, with guidance from the District Court, engaged in discussions of how to properly vindicate, in light of substantial law enforcement, investigative, and individual privacy concerns, a public interest in transparency of records concerning the government's use of statutorily authorized investigative tools. The government acknowledged that applications and orders relating to electronic surveillance methods need not necessarily be permanently sealed, and it released some information. With respect to past filings, the applicants ultimately received information about the total number of electronic surveillance applications and more specific about Pen Register orders, including basic docket information, for a 9-year period. Certain details the government extracted from the files of 10% of the Pen Register matters, and the unsealing, with redaction, of 4 sample Pen Register applications and orders. The parties eventually reached an impasse. Regarding past filings, the applicant still sought basic docket information for the Section 2703 matters and specific details to be extracted from 100% of Pen Register matters filed before the United States Attorney's Office since 2008, both involving only closed investigations. So these are not investigations in process, they're already closed, and so therefore the law enforcement interest is, of course, significantly diminished. The common law right of public access to judicial records is a fundamental element of the rule of law important to maintaining the integrity and legitimacy of an independent judicial branch. In 1978, the Supreme Court held it was clear that the courts of this country recognized a general right to inspect and copy public records and documents, including judicial records and documents. In light of these considerations, there is strong presumption in favor of public access to judicial proceedings, including judicial records. Having concluded that the documents sought by the applicants are judicial records to which the Hubbard test applies, we now address the applicant's principal challenge to the manner in which the district court applied the test, the court's determination not to unseal the records because of administrative burden. Under the requisite Hubbard test, a seal may be maintained only if the district court, after considering the relevant facts and circumstances of a particular case, and after weighing the interests advanced by the parties in light of the public interest and duties of the court, conclude that justice so requires. The Hubbard test requires a district court to weigh the following 6 factors: the need for public access to documents at issue, the extent of previous public access to the documents, the fact that someone has objected to disclosure and the identity of that person, the strength of any property and privacy interests asserted, the possibility of prejudice to those opposing disclosure, and the purposes for which the document were introduced during the judicial proceedings. Under Hubbard, the district court said a court may consider administrative burden in deciding whether to recognize any particular right of access in the first place, not just that such a right of access exists, but nonetheless give way to countervailing consideration. A court may conclude that no asserted common law right of access exists in the first place when recognizing such right of access would impose an undue administrative burden. The government does not defend that particular conclusion, however. It is undisputed then, in considering the legitimate interests identified at Hubbard, a court may reasonably find the administrative burden of protecting those interests should affect the matter of timing or unsealing. As the district court said, the clerk's office cannot simply press prints on the records and unseal docket information that might jeopardize personal privacy or ongoing investigations. Although the administrative burden is relevant to know how and when the documents are to be released, it does not justify precluding that release forever. The records at issue here are not nailed into a nondescript crate, stored deep in a sprawling, uncategorized warehouse. Compare Raiders of the Lost Ark by Lucasfilms Limited 1981. Production may be time-consuming, but time-consuming is not the same thing as impossible. Providing public access to judicial records is the duty and responsibility of the judicial branch. Precluding public access because of personnel hours required to produce those records is no more warranted than precluding public access to high-profile trials because of the cost of crowd control. Administrative burden, when taken into consideration as necessary to protect other relevant interests, may affect how and when judicial records may be released, but is not dispositive of whether judicial records may be released at all. The district court has already taken important steps to ensure the transparency of filings related to electronic surveillance orders at the issue in this appeal. We remand the case to the court to determine, in sound discretion, how and when greater access can be provided. Thus, that brings us to the end of the discussion of in re in the matter of application of Jason Leopold to unseal certain electronic surveillance applications and orders. In this case, Jason Leopold wanted access to government surveillance records dealing with pen register and stored communications, and the government district court said no because it will be really, really hard. And the Court of Appeals said no, really, really hard is not a good enough reason. You obviously can control how and when, because you have other things to do with your time and you have limited personnel. So we understand that. But, you can't just say no forever. So, go back and figure out something that is a reasonable schedule and give them access to the documents, because we presume that people get access to public records. And these should be public records, particularly if there's no public interest in public investigation ongoing, which there's not. And if you want to redact some names of something for privacy, I understand. But otherwise, this is public information. And so that's a pretty good decision. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.